Understanding the law is the first step to fighting back. Here's what federal agencies just decided and what it means for your family. If you hold a green card, 2026 is bringing changes that reach into your daily life, your business, your travels, your long-term security in this country. This video breaks down what is actually happening and what you can do about it. Let's start with a change that has immigrant entrepreneurs across the country scrambling. On February 3rd, 2026, the Small Business Administration, the federal agency that backs affordable loans for small businesses, announced it would no longer guarantee loans for any business that includes green card holders among its owners. The rule takes effect March 1st, 2026. Under the new policy, cited as SBA Policy Notice 5000-876441, 100% of all direct and indirect business owners must be U.S. citizens or U.S. nationals with their principal residence in the United States. Even a 1% ownership stake held by a lawful permanent resident disqualifies the entire company. To understand what this reverses, for decades, the SBA's policy required only that 51% of a business be owned by citizens, nationals, or green card holders. A permanent resident could own the majority of a business and qualify for federal-backed financing. That changed briefly in late 2025, when a narrow 5% foreign ownership exception was allowed under certain conditions. Now that exception is gone entirely. The programs affected are the SBA's flagship 7A and 504 loan programs, the ones used for working capital, equipment purchases, and real estate. These loans are attractive precisely because they carry lower interest rates, longer repayment terms, and government guarantees that reduce lender risk. Losing access means turning to conventional financing, higher down payments, stricter credit requirements, less favorable terms overall. There is one important deadline to understand. If your SBA loan application was assigned a loan number before March 1st, you are grandfathered in under the previous rules. If you are still in the application process and have not received that number, time is running out. Critics of this policy are pointed in their objections. Carolina Martinez, CEO of Cameo Network, a national small business support organization, noted that closing off this funding stream will hurt not just individual business owners, but local economies, dampening job creation and tax revenue. Democratic lawmakers have called the policy a reversal of decades of SBA mission and an attack on immigrant entrepreneurs. Senator Ed Markey of Massachusetts described the administration's citizenship verification requirements as another failure to serve American small businesses. The data adds context to those concerns. Immigrants own roughly 18 to 19% of all U.S. small businesses with employees, generating over $1 trillion in annual revenue. In fiscal year 2024 alone, the SBA backed more than 8,900 loans to Asian-owned businesses, totaling $7.2 billion. Lenders estimate that 5 to 15% of existing SBA portfolios involve green card holders who would now be ineligible for new funding. If you hold a green card and own a business, you have options, but you need to act deliberately. Conventional bank loans remain available. Credit unions may offer different eligibility criteria. Community development financial institutions, known as CDFIs, exist specifically to serve small businesses that struggle to access traditional credit. If you are eligible for naturalization, this is the moment to take that process seriously. And if you co-own a business with U.S. citizens, consult an attorney about whether restructuring ownership is a viable and legally sound path for your situation. Now, the second area of change involves travel. Green card holders have long understood that international travel requires care. But in recent weeks, a pattern has emerged that goes beyond what was previously required. Lawful permanent residents traveling to and from countries included in the administration's travel ban lists, 39 fully banned countries, and a broader group of 75, are being pulled into secondary inspection upon re-entry into the United States. In most reported cases, these inspections result in eventual release. But the delays are real, And for people with connecting flights, the consequences are financial. Missed flights, rebooked tickets, hours of additional interrogation without a clear outcome. At the same time, requests for phones and social media access at ports of entry are increasing. As a green card holder, you have more legal rights than a visa holder at the border. You are not required to unlock your phone or provide access to your accounts. But exercising that right may extend your wait time considerably. The practical reality means preparation is your best protection. Before you travel, prepare a one-page summary of your history as a lawful permanent resident. Your length of residence, the purpose of your trip, your family, home, job, and community ties in the United States. Carry documentation. Leave time between connecting flights. Know that most green card holders return without incident. And also know what to expect if you are among those asked to stop. The third area of change involves green card applications, specifically who can get one and how that process is being scrutinized. A proposed rule from November 2025 would significantly expand the public charge ground of inadmissibility for people applying for green cards. Under existing law, officers can deny permanent residency to applicants deemed likely to become primarily dependent on government assistance. The proposed rule would remove the existing regulatory framework that defines how that test is applied, replacing it with broad officer discretion. Advocacy organizations have warned this creates conditions for arbitrary and inconsistent decision-making. If you are currently a green card holder, this proposed rule does not affect your existing status. Green card holders are generally eligible to use public benefits. But if you are in the process of applying for a green card or supporting a family member through that process, this is the moment to consult an immigration attorney about what is in your file and what you may need to address. A fourth development involves retroactive review of previously approved immigration benefits. In January 2026, USCIS issued a policy memorandum directing a review of approved benefit requests, including green cards, for nationals of countries on the administration's high-risk list, going back to January 20th, 2021. Cases may require additional interviews and screenings. For refugees admitted between 2021 and 2025, a separate internal memo calls for a comprehensive re-review of an estimated 200,000 cases. To be clear, the legal authority for rescission of adjustment of status is narrow. Under INA Section 246, USCIS can initiate rescission only within 5 years of an adjustment, and only if the person was not eligible at the time the green card was granted. But the re-review policy means that cases within that window, involving nationals from affected countries, may face new scrutiny. If you believe your case could fall within this scope, document your eligibility and connect with a qualified immigration attorney. Finally, a broader shift is visible in how the administration prioritizes immigration categories. Employment-based petitions for high-income individuals, including the proposed Gold Card program requiring a $5 million investment, are receiving priority. Family-based petitions, the F2B, F3, and F4 categories that represent decades of waiting for ordinary families, are seeing longer delays in comparison. If you have a pending family-based petition, keep your paperwork current, respond promptly to every government request, and know that a mandamus lawsuit, a federal court action compelling the government to act on a delayed case, remains a legitimate legal tool. Here is what all of this means, together. If you are a lawful permanent resident, you exist in a legal category that was once considered stable, protected, and fundamentally respected. The changes accumulating in early 2026 are creating a new landscape. Economic opportunity restricted, travel scrutinized, past approvals subject to re-examination. The weight of that falls on real people. Entrepreneurs who built businesses over years, parents with U.S. citizen children, community members who have paid taxes and contributed without question. Stay informed and know your rights. Record today, protect tomorrow.